Hello, everyone. I'm Dr. Dale Caldwell, the Executive Director of the Rothman Institute of Innovation and Entrepreneurship, and we have Michael J. Marotte from Schenck firm. It's going to be a real interesting discussion, as they all are today. Just a little bit about Fairleigh Dickinson University, for those that may not know that we in the Institute was founded about 31 years ago. Our focus is on family businesses, veteran businesses, student businesses, and we're growing our practice in urban businesses to really help entrepreneurs understand the landscape, come up with some technical information that can really help them not make mistakes that others have made. And we do mentoring programs as well. So we are all in and really advocating for this sector of society. So we bring brilliant people like Michael to really kind of tell you some real insights on what's the latest information about that every small business person needs to know. So Michael, I want to welcome you, and I like to begin with understanding, where did you grow up, and you had an interesting career going into law. So why don't you tell the audience, how did you do that, and where did you grow up?
Good afternoon, Dale. Thank you for that. So I actually grew up in Staten Island, New York.
Okay.
In a place that feels long forgotten. I haven't lived there in decades, but that's where I grew up. I got a degree in chemical engineering.
Wow.
So I was actually a practicing chemical engineer for a few years before I decided to go to law school. So I did have
Where'd you go undergrad? Where did you get the chemical engineering degree?
I got a BS in chemical engineering from Rensselaer Polytechnic Institute.
Holy cow, that's the best out there, RPI.
At the time, I can't say where it is now, but in the 80s when I was there, the early 80s, it was considered one of the best undergraduate engineering.
Oh, absolutely, especially for engineering. I mean, that was great. And then you said, what did you do right after that? You worked for a couple of years.
I did. I worked for a Fortune 50 company, had a great job, and then decided to go to law school.
Wow. And where'd you go to law school?
Rutgers Law.
Nice. Okay. Great. And so I had an opportunity yesterday to do some diversity, equity, inclusion training for the Schenck firm. We had probably about 60 people. What an amazing firm! What an amazing group of people! And so I'm glad you were able to participate in that. So what's been your practice? Did your practice evolve? And so take us through your law career. So you started out somewhere as an associate, you became a partner, and then what happened in your law career?
So then there too, there was a lot of turns, and people should recognize that there's going to be turns in their lives. So I started out at a small firm as a trial lawyer, and for the first 10 years of my practice, I was a trial lawyer. I was the guy you called to try a case. I tried 30 jury trials.
Wow.
was pretty good at it. And then my practice segued into business and corporate law counseling, and really the last 20 that has been my focus. But where the litigation and the trial work has proven invaluable is, when you're doing a transaction, setting up a company, having litigated cases, you know where the pitfalls are, you know where the risks are.
Well, let's go back, because, and I love busting stereotypes, as you can tell from my session yesterday. So a chemical engineer, you're supposed to be in a cubicle in a corner somewhere. How can you be a litigator if you're a chemical engineer? So talk to me about that transition. That's I love the diversity.
I don't think it wasn't intentional. It wasn't part of a plan. I didn't graduate law school saying I'm going to become a trial lawyer.
Right.
Sometimes opportunities present themselves. It turned out I had a pretty comfortable demeanor, which allowed me to connect with juries, and it worked very well. And the segue into business and corporate law was really just an offshoot of counseling those clients in their litigation, and then ultimately coming to Schenck Price, where we have 85 lawyers basically covering all areas of the law. I was able to draw on a lot of expertise to provide those clients with extra guidance beyond litigation, and then eventually I adopted that expertise.
Well, and normally people would say, okay, well, chemical engineering, a lawyer, you'll be working in Texas for the oil, oil companies. And so I'm sure you got some offers there. Did you consider that at all?
I did. So I was actually I was an engineer with a company called Ashland Oil. They make Valvoline, some name brand products. It's a Fortune 50 company. It was more exciting to go into the firm environment where you're going to see a lot of different things. And to this day, that's the practice.
Right.
Phone calls come every day, and there's new and interesting opportunities to work and to hopefully add some value for clients.
Wonderful, wonderful. So let's talk about this. So you have your slides up, small business formation and governance. Let's hear a little bit about what you're working on.
So what we're going to talk about today is I'm going to take you very briefly through some things entrepreneurs should think about when they're forming their company,
Wonderful.
how they should form it, where they should form it. And then we're going to talk about governance, which is far more important. And I'm not going to go through horror stories, but I have several where very good friends, lifelong friends, formed a company, didn't set up governance properly,
right?
Inevitably, and often as a consequence of their own success, conflicts arise, and sometimes with disastrous results.
Yeah.
And so what I tell people, entrepreneurs, younger people starting companies, set up the governance right from the beginning. It's money well spent. Now, there may be a caveat there. If you're going to be a sole proprietor, I actually have reasons why you should still set up governance. But for a sole proprietor, it's a little different. But if you're going to have partners, if you're going to have members in an LLC or shareholders in a company, you must set up governance. And so
we'll talk, especially, I'm dealing with some family businesses that didn't do governance right, and they're suffering the consequences now because of that. So yeah, let's talk about formation.
All right, let's roll into it. So first decision you're going to have to make as an entrepreneur is, are you going to form a limited liability company, a C Corp or an S Corp? Or are you going to form something a little different, a limited partnership or a general partnership? Almost all of these offer very similar liability protection. And what it ultimately comes down to is tax. And the tax considerations are best dealt with your tax professional or a tax attorney. I can certainly offer some guidance there. Most folks gravitate towards limited liability companies because they're the simplest. Most will not gravitate towards a C Corp because you will have two layers of taxation. You'll have taxation at the corporate level and also at the shareholder level. Right. So it's usually a debate between a limited liability company and an S Corp, and that's actually driven by tax.
So I understand, I learned today that there have been some changes in the S Corp law, which we'll talk about, right? Or their proposed changes. So let me ask you this, for people on, if you're already one of these, can you switch? Can you be an LLC and then go to be a C or an S?
You can, and again, there's tax issues there. It depends on a lot of factors. And when it comes to contemplating converting, I always pull in a tax professional. Yeah. It's always tax driven. But the important thing for all the folks on this webinar is the liability protection is virtually identical, and you're always going to want to have the protection, the corporate shield, which is part of either a limited liability company, a C or an S Corp. Now, there's ways to pierce that shield. Yeah, there's ways to pierce that shield, which aren't really the topic of this discussion. Right. That could be a whole nother seminar. But if you form the company properly, respect the corporate form, you should have liability protection.
Okay, and you're going to break down each of these for us?
Yeah, I'm going to roll through it right now.
Perfect. Great.
So regardless of whether you're an LLC or an S Corp or even a C Corp, you're going to have some form of a governing document. Mm-hmm. For corporations, they're going to be a bylaws and a shareholder agreement. For LLCs, it's an operating agreement. Different nomenclature, different legal forms, but the idea is the same. We're going to be identifying the folks who are responsible for governance. So in the case of operating agreement, it'll be managing members. In the case of a corporation, it'll be board members. And in both instances, they'll be officers, but officers are never required. What I always caution people on is, regardless of the form of form of corporation that you've elected to form, you need to have an orderly process for the removal of a manager or a board member who isn't performing well. Right. And you also need mechanisms for the replacement of managers and board members who retire or go in a different direction. We're going to talk a little bit about that, and some of these issues become very, very interesting. And I'll tell you some real world stories about very significant corporate reorganizations that were that came to be in part because of governing documents that I had drafted, and they did work the way they were intended to. So I'm going to keep rolling through this because we'll get into some detail now.
Yeah, now, before, Mike, and I hope you don't mind my interrupting.
No, I welcome it.
Audience may. LLP, so limited liability partnerships. Is that like an LLC, except it's a partnership?
It's very similar. And
Okay.
in fact, my firm, Schenck, Price, Smith and King, is an LLP. You'll see it at
Okay.
the bottom of the slide. So we're a limited liability partnership. Each of our partners has limited or no liability. Most of our liability is by contract, not by operation of law. And a general partnership is what you see very often in real estate deals or real estate syndicates, where you'll have a general partner and limited partners below. The limited partners in those instances are mostly, you can think of them more like silent investors. They're going to invest money as a limited partner. They're going to have very little governance rights. They'll have information rights, but they're not making decisions. They're merely an investor.
Okay.
Right. So now we've formed our company. We've identified our managers or our board members, and we want to identify their duties and responsibilities. This proves to be very, very important, especially in small, closely held companies that are new. Who's responsible for what? And who's going to make decisions that affect the company? Very, very often in an LLC, you'll have a single managing member who's going to make a lot of decisions and are going to run the day-to-day operations. That works very well for some companies. In other instances, it'll be board managed. Same idea. The board's going to have certain decisions that it's going to make. But then you get into another level. Well, what decisions are going to require the majority vote of the board or the members or the shareholders? What decisions are going to be reserved for some supermajority, and what decisions are going to require unanimous approval? For example, and this sounds obvious, but it might not be. Typically, you're not going to allow the governing documents to be changed without unanimous approval, right? If you happen to be, Dale, if you happen to be a 1% owner of the company, you're still an owner, and you're not going to want the governing documents that affect your rights and responsibilities to be changed without your consent.
Right.
In California, that's actually the law. If you have a California company, unanimous approval is in fact required before you can change the governing documents. Now, the flip side of that is that can be paralyzing, right? Dale's a 1% owner of our company. We do need to change this operating agreement, and he either is not responsive or won't agree. So these issues have real world consequences. Then what we often do is we're going to identify a list of what we call major decisions. Decisions that are going to require some approval of the members or the shareholders, whether majority, supermajority, or unanimous. The next few slides are going to go through a lot of these, and I'm just going to go through them quickly because you'll get the gist. They're decisions that affect they're not day-to-day operations. They're much more important than that, right? Merging or acquiring substantially all the assets of another company. You're going to merge with another company. You're probably going to want to build a governance structure where the majority of the members or shareholders are going to approve that, or maybe supermajority or unanimous approval. Entering into a transaction that's going to change the control of the company. Wow. That's important. And to be fair, some majority of the members or owners should approve that. The next one is a very thorny issue, requiring capital contributions. I'm going to spend a minute or two talking about that. Companies sometimes need money. And who makes the decision about whether the company needs money? It's a decision fraught with peril, because there are instances where the more well-funded owners of a company will demand, and if they have the power to demand, capital contributions that the less well-funded owners, they can't make the contributions.
Right.
And the failure to make a contribution inevitably has some consequences, which we're going to talk about.
Interesting.
So depending on which side of I'm representing, whether I'm representing a single shareholder or member or the company as a whole, we spend some time talking about how capital contributions are going to be required and what are the consequences for failing to make the
Sounds a lot like poker. Sounds a lot like poker. You need to put, you put your hand in, and if you can't, match it.
Well, all true, but let's think of some nefarious a nefarious example. Dale, you and I are extremely wealthy, and we form a company. We have a third partner who is just frankly not as wealthy as we are, but we're equal 1/3 owners.
Right.
Majority controls, and you and I form a nice majority, and we decide we need capital contribution, which our minority, which the other owner just can't afford.
Right.
and he's now diluted. We're going to talk about that a little bit later.
Wow. Okay.
And you and I can essentially force him out or force him into a compromised position.
Right.
It's
Wow.
not fair, right? On the flip side, and there's always two sides to the coin.
Right.
The company could legitimately require money.
Right.
We need to buy new equipment. We need to enter into a new lease, whatever. And that company can't be compromised because one or more of our partners either can't or won't make the contribution.
Right. Right.
Borrowing money beyond a certain threshold, it's a good idea, whoever the governing folks are, that they can't go out and borrow substantial amounts of money on behalf of the company without some majority or supermajority or unanimous approval. So these are some typical major decisions. There's a lot more. And some of these are more important than others. Incurring liability beyond a certain threshold is the same idea behind as borrowing money. Acquiring or selling real property. Do we really want our managers to buy or sell property without the approval of the majority or supermajority of the members? So it's a valid question. Selling all or substantially all of the assets of the company. I don't know that we want to trust a manager or board with that decision. We might. It depends on the facts. This next one's very important. Issuing new membership interests. If using our example again, Dale, it's me, you, and another person, we have a company.
Right.
We may not want to have other members or owners join the company. It's a small, closely held company. We know who we are and we like who we are. Are we going to admit new members? What's the approval mechanism to admit new members? Next one is engaging in litigation beyond a certain threshold. We don't want our managers, our board members, to file lawsuits without good reason. Certainly the next one, filing for bankruptcy. That should be a decision that's reserved to the members or shareholders. Winding up or dissolving the company, same idea. Before we wind up the company, there should be some majority or supermajority approval.
Right. Michael, if you look in the question, there's a question, I can read it off to you from Kevin Curran. Kevin, thanks for the question. What is your preference when an owner of a single member LLC seeks to move the business to a corporation structure for purposes of bringing in investors? Is it better to merge the LLC into the corporation versus transferring all equity ownership of the LLC to the corp, making the LLC a subsidiary of the corp, and then winding down the LLC as the business operations shift from the LLC to the corp?
Great question. Can't be answered without a tax review. What we did just in the last few weeks, and I'm going to talk about this particular example, it was an LLC, started small. I actually started working with them when they were a little storefront. That company is now worth multiples of $1 billion in about,
wow, really? Wow.
In about 10 years. It's been a great success story. And they are in fact taking in private equity money now. And as is often the case, we were needed to convert the LLC to a C Corp.
Okay.
Many private equity funds or investors are more comfortable with the C Corp structure. It works better. And many, for reasons that I don't agree with, are more comfortable being in Delaware. So what we did in that instance was we formed a new Delaware C Corp. And this was approved by all the tax professionals.
Right.
We formed a new Delaware C Corp, merged the old New Jersey LLC into the new Delaware C Corp, and then dissolved the old LLC. That decision, the goal there was to ultimately have a Delaware C Corp. The mechanism on getting there was driven by tax analysis.
Interesting. So it depends.
It depends.
But very, very, very interesting. And so Delaware, I mean, everybody goes to Delaware. I've formed, I have an operating agreement from Delaware. Now, why don't you like people going to Delaware?
So I'm going to be a little, I might be an outlier here. Delaware for many, many years had a better body of corporate law than just about any state. They were just in front of everybody else.
Right.
They had better corporate governance statutes, but most states have caught up and are just as friendly, both from a formation and filing standpoint as Delaware. Right. I actually went to a CLE given by Delaware attorneys a couple of years ago where they talked about why Delaware is still the best, and it just didn't ring true with me. The other problem with Delaware, and I tell all my clients this, is it's much more expensive to form and maintain a company there. The franchise tax can be many tens of thousands of dollars, where in New Jersey, it's $165 a year.
Wow.
That's just one example. And I just don't see any real benefit. Having said that, a lot of investors, PE firms, are still more comfortable with a Delaware corporate structure. And case in point, we converted our New Jersey LLC to a Delaware corp to satisfy them.
Interesting. But now New Jersey has not caught up to some of the other states. Is that correct?
There's some deficit. I happen to know he's older than me. He's a great guy. The senior attorney who was responsible for drafting New Jersey's revised Uniform Limited Liability Act. I think they did a great job. I think it's as good as Delaware's.
Really?
Wow.
Wow.
Are there some deficiencies? There probably are. Some other things that people don't often think about, but might be important. Some states, the members of the company are disclosed upon formation. Delaware is not one of them. New Jersey is not one of them. But if you form in Florida, for example, all the members have to be disclosed, and it's public information. So Dale, if you form a Florida LLC, I could look it up right now and find out who the members are. Some people aren't comfortable with that level of disclosure.
Right.
Yeah, and that decision, segueing a little bit, that decision should not be tax driven. A lot of people make the mistake and think, I'll form my LLC in Florida. There's no corporate level, there's no state tax in Florida. There's no state income tax.
Right.
It doesn't matter where the entity's formed, it's where the revenues are earned. So you can form your entity, you can form your entity in Florida. If revenues are earned in New Jersey, you're paying New Jersey income tax.
Interesting. Okay. Fascinating. Okay, I didn't want to slow you down.
And so Dale, I for whatever reason, I can't see the questions, or maybe can't see them as readily as you. So please interrupt me if there's any questions.
Okay, perfect. And Kevin, I hope we answered, that's a great question. Hope we answered that.
And so these are just more general major decisions. We don't have to go through them. But again, the concept is, what major decisions should be reserved, not for the managing member or the governing board, but for the members or shareholders at large. So capitalization, we touched upon this, and let's talk about this a little bit more. Very often you're going to identify the initial capital contributions. Dale and I each put in $10,000 when we formed our company. That's really for tax purposes. We're going to have capital accounts that our tax professionals will maintain, but there has to be a starting point. The second one's the important one. When new capital is required, what are the mechanisms for asking for that new capital among the members or shareholders? And what are the consequences for the failure to fund or make that capital call? Sometimes the failure or refusal to make a capital call it's with good intentions. I just don't have the money to make the capital contributions. Sometimes I just don't want to, but there has to be a consequence when that capital call isn't funded, right? There has to be some penalty. And the penalties can range. They can be any number of mechanisms. Most of the time, they will end up in dilution. So in the example where Dale and I and our third partner are equal members in an LLC, and we need another $10,000, if our other member just can't or won't contribute, what can happen, and what often does happen, as spelled out in the governing documents, is Dale or I can fund his share or her share. Will fund it, and it is converted into a loan, which, if not repaid back in some time, right? So the defaulting member will have a year to pay back that loan.
Right.
If he or she has not done it, he or she will be diluted by a prorated amount. And now if I was the funding member, I own more of the company at that point. Right. That's one mechanism. Other mechanisms could be the withdrawal or the forced withdrawal of that member. That's pretty draconian. But you have to consider the reality that the company will need money, and there has to be a fair mechanism to get that money.
Will you, and I'm sure you've seen this a lot, when you talk about divorce. So here, that the impact of divorce and all of this stuff can be.
Dale, there's a slide there's a slide coming up where we're going to talk about divorce.
Okay, good.
That's a very prescient comment, because it's one of the thorniest issues that we're going to deal with in governance. Yeah. So that is going to come up in a slide. Yeah. The next topic, right? We formed this business. What we are ultimately interested in, beyond doing good in the world, perhaps, is how are we going to get paid? What money are we going to get? What distributions are coming our way? In a LLC, there'll be distributions paid. For a corporation, there'll be dividends paid. What is the mechanism for making distributions or dividends? Who's going to make the decision to pay the dividends or distributions? And now again, you see the same risk that you saw with with capital calls, where there's a mechanism or a possible mechanism here for some financial blackmail, right?
Right.
Let's say I'm the manager in our company and I've been given authority to decide when we're going to pay distributions. I happen to know, Dale, that our other member really needs the distributions, and we're trying to force him out.
Right.
We're just not going to authorize dividends or distributions. That's a bad example, right? You've given me too much authority to render distribution. So we're going to want to control that authority in some ways. Now, you don't have to control it. We could be three people who grew up with each other and we're buddies and we've known each other for 40 years and you trust me completely. But I've seen those instances where that trust evaporates and it doesn't end well.
Yeah.
So let's put it in writing, right? What is the mechanism for making the distributions or dividends? One option is you do give the managing member or the board the first right to suggest that a distribution is going to be made, maybe subject to the approval of the members or some majority of the members or owners. Alternatively, you can give the members and the shareholders some authority by majority or supermajority approval to demand a dividend or distribution. So there's always this tension about when dividends should be made. Now, in the real world, most companies are run honestly, and dividends are paid when they can be paid. Distributions are paid when they can be paid. We had a great quarter. We're gonna make distributions. We all want the distributions, so we're gonna make them. One thing you're going to want to deal with in your governing document is the priority of distributions. Almost always, the first distribution is going to be a tax distribution. Companies and LLCs have something called phantom income, right? So the LLC or the S corp has made money, but we didn't distribute it for reasons that are ours. We might have invested a lot of money in advertising. We might have done things with that money, or we may have held that money for a rainy day. Unfortunately, Dale and I and our partner, we're going to owe income tax on that money, whether it was distributed or not. Wow. So we're going to want a tax distribution, enough money at least paid to us to cover our tax obligation.
Right.
The second order of priority, which you often see, is the repayment of member loans to the company or to other members. Again, instances where somebody's failed to make a capital contribution, we may take that person's distribution, right? The defaulting member, and instead of getting the distribution, his money may be used to repay back that loan so that he or she doesn't get diluted, and also just to right the ship. The third level would be the return of capital, and then the fourth level would be to the members pro rata. In my example, Dale, I, and our partner are 1/3 members each. Any money left over is going to be paid out to each of us 1/3.
Right. Now there's another question. I don't know if you scroll down, you can see the Q&A. I'll read it to you. But another one from Kevin. When new capital is required, but the operating agreement has not deviated from the statutory default rule under RULLCA that distributions are per capita among the members, how do you propose dilution when each member still gets a per capita share?
So dilution can be a very complicated formula, and we struggle with that. Kevin's got great questions. So the member, in my example, who failed to make a $10,000 contribution, how do we determine how much he's diluted? There are multiple formulaic mechanisms to decide that. Some are based on capital accounts. So if his capital account at the time was $100,000, there was a capital call of $10,000, which he failed to make, there's a theory that says he should be diluted by 10%. There are other formulas, none of which I find completely satisfactory, and it's always a struggle. But the concept is there will be some form of dilution.
Right. Okay. Great. Thanks.
Next major topic for governance. What are the transfer restrictions? We're not owners of Apple stock that we can just decide to sell. Dale, I, and our partner, we're a closely held company, and I don't want Dale to sell his shares to anybody, even if he could. But Dale doesn't want to be an owner for the rest of his life, conceptually. Right. So we're gonna create a list of permitted transfers, and these are pretty basic and usually not controversial. Dale can certainly transfer to an entity he owns. He may want to put in the name of an LLC or holding company. Dale may want to transfer for estate planning purposes to a trust. We almost always allow that. We often allow transfers to existing members. We don't want new people coming into our company. We're a small, closely held company, but we can certainly change ownership among ourselves. And the last category, which is often included and allows Dale this opportunity to sell out if he wants, is basically a sale to a third party subject to a right of first refusal. So Dale finds a buyer for his shares. And by the way, we own an ice cream store and we've been making money. It's a great business. But Dale's done. He wants to move to Florida and retire, and he wants to sell.
Right.
He can offer if he's allowed to sell to us, he can offer it to us first. And if we say no, he finds somebody who will buy his shares. At that point, we would like a right of first refusal, right? I want to at least have the ability to say, well, I don't want to be partners with this new person. I don't really know them, but you certainly have a right to be bought out, and this is how we're going to do it. I'll match that offer. And Dale, you can move to Florida. So these are very typical, or you can have no restrictions. I mean, it's not inconceivable that you can simply sell. As everybody probably knows, selling ownership interests in closely held companies is not that simple.
Right.
There's a lot of reasons why it's difficult, and but we're going to want to again establish these rights and these restrictions up front.
And now, what do you do if, and dealing with this with some family businesses, where there's say two brothers and there's conflict between the brothers, and one's really working really hard, the other one's not working at all, but they've not done any of these governance things. How do you put them in after the fact?
Dale, you're a great partner, so you can't really put them in after the fact.
Right.
You could dissolve the company, or you can have mechanisms for forced transfers.
Okay, perfect. Wow. Okay.
Yeah. So one of them is, I'll go out of order, is a voluntary withdrawal or involuntary withdrawal, and this is a real world example where one of the companies that I represented, that is now worth well north of $1 billion, had 4 or 5 founding members, and one stopped working. Right. This is your example. Yep. One stopped working. Yep. Company was successful, and this isn't the example, the real life example, but I'll make it my hypothetical. This company's doing great. We're making a lot of money. I'm moving to Florida, mail my checks to Florida. The problem with that is the company depended on me for logistics, or depended on me for manufacturing or whatever, and now I'm simply in Florida. Well, you can't fire me because I'm an owner. Right. So what can we do? And in the real world example, the operating agreement that we had drafted had a mechanism to remove a member who ceased working. Now he got a buyout, and a very rich buyout, based on a formula. At the time, the formula that we had developed was based on EBITDA. It could have been fair market value. I'm going to talk about that a little later. So in each of these elements, I'm going to go through them, right? Bankruptcy, death, disability, divorce or marital distribution, which you mentioned before, a felony conviction, something bad has happened, right? In one instance, Dale, I'm going to pick on you. Dale declared bankruptcy. His ownership in our company is going to be subject to distribution in bankruptcy, and I don't want it bought in bankruptcy. Right. I don't want there to be some bankruptcy sale, and I now have a new partner that I don't know. Right. Under those circumstances, Dale is going to be deemed to have offered his ownership interest for sale. The purchase price, which I'm going to talk about, is down below, but Dale is now insolvent or bankrupt, and he's deemed to have offered his shares for sale. Death is another example. We regret Dale has passed away. In this instance, I don't know what Dale's estate plan is. I don't know who his heirs are, and I don't really want to be partners with them. So we're going to, upon Dale's death, there's going to be a deemed offer to sell. Now, death can be dealt with differently. You can buy insurance policies, you can buy key man policies, and I always recommend this, so that when Dale dies, there's a key man policy that the company has paid for, which
Right.
will essentially buy out Dale's interest. The company will have the cash from the policy. It will go to Dale's estate pursuant to a formula that we're going to talk about in a little while. And if we're generous, we can actually make some extra money, just go to Dale's estate. Key man coverage is always recommended. It's often
Right.
term policies. They're often very inexpensive. It's a deduction for the company. I strongly recommend it.
Yeah.
Disability is important only if Dale was contributing to the company. He was in charge of manufacturing, and now he's physically or mentally disabled, and he can't do that anymore. We're gonna buy Dale out under those circumstances.
Okay.
The one Dale mentioned, which is really the most interesting, divorce or marital distribution.
Right.
We don't care if Dale gets divorced; that's his personal business. But if Dale gets divorced, and as part of the marital distribution, his wife now owns half his shares, I
Right.
do care about that, because as much as I like Dale's wife, I don't want to be partners with her.
Right.
And so under those circumstances, there's going to be a deemed offer of sale. Conviction or guilty plea of felony, this is personal choice. Do we really want to be partners with somebody who's been convicted or pled guilty to a felony? It might not matter for business purposes, or it might.
Right. Right.
So what's the purchase price in all these examples, right? Because you're an owner. I can't just take your shares. So there's different mechanisms. It can be based on a formula. It can be based on some multiple of EBITDA, and that often works for a lot of companies. It might not work depending on where we are in the life of our company. We may not have very much in the way of EBITDA. It can be based on an agreed to value, which sounds very simple. Dale, we agree our ice cream company is worth $1 million.
Right.
And we both agree that's what it's worth. Well, that was true today.
Right.
5 years from now, when we pull the document out of the drawer, it might not be worth $1 million. It might be worth $5 million. So when I counsel clients, I suggest that they can have an agreed to purchase price, but they have to commit to revisiting it every year and making sure that price still works.
Mm-hmm.
The other option is simply fair market value. It will be fair market value. That sounds nice, and it is, but what is fair market value? Some businesses are notoriously difficult to evaluate.
Right.
It's one thing if we're a real estate company, we own real estate, that feels pretty easy. We can establish fair market value. It's
Right.
quite another thing if we're a startup with no real revenues.
Mm.
So fair market value has its pitfalls. What we try to build in, if we're going to use fair market value, is some appraisal rights. First of all, the parties can always agree on fair market value. If they can't, let's build in some appraisal rights and some mechanism to object to the appraisal. So we will do that. Other types of forced transfers are drag along and tag along rights. So a drag along right is best explained by an example. Dale and I, in my example, own 2/3 of the company, and we found a great buyer for our company, just a great buyer. Our agreement says if more than 50% of the members want to sell, we get to drag along the minority member, our partner.
Right.
And he or she must sell along the same term. So we've dragged that person in. So drag along rights really protect the majority interests, perhaps at the expense of the minority interest, but they're fair because, I'll change the hypothetical, we don't want a 1% owner of our company to stop the sale of a company. We have to be able to force that person to be dragged along.
Right.
The tag along rights are the flip side to that. Sometimes the tag along rights protect the minority owners. The minority owner will often want the right to tag along in the purchase and sale. Dale and I own 90% of the company, and we're going to sell the 90% to a buyer, and that buyer is very satisfied with 90% because he or she's going to own virtually the whole company and control it, and doesn't care about the 10% minority owner. But I'm the 10% or in this example, the other shareholder is the 10% minority owner, and he or she cares.
Right.
He or she may insist on the right to tag along. These rights need to be spelled out in the governing documents. I always flag these rights, right? I want the members, shareholders to understand their options here, and then they'll make decisions about whether they want to include drag along rights or tag along rights. In both instances, it's important, the drag along and tag along rights. Those rights are exercised with the same terms of the majority deal, right? The person who's tagging along doesn't get a better deal or a worse deal. He or she gets the same deal.
The same. Now we have another question. Another one from Kevin. These are Kevin is very knowledgeable. How often do you see dissociation used rather than forced transfer? Example, due to willful and persistent breach of the operating agreement or being unable to continue working with the other members. Dissociation leaves the transferable economic interest after removing the membership, whereas the forced transfer presumably removes the transferable economic interest also, especially if the operating agreement is silent as to any permitted forced transfer means.
Well, if the operating agreement is silent, you're stuck.
Right.
And then you're going to have to do some type of dissolution or forced dissociation, which is incredibly messy. And I have not seen it happen. I shouldn't say I've never seen it happen. I've never seen an instance where 3 of the 4 members file a lawsuit to disassociate the 4th member. I have seen lawsuits to dissolve the company in its entirety, which obviously is the nuclear option, and just not a good idea. So if you're in a situation where you don't have governing documents at all, or you have governing documents that don't allow for the removal under these circumstances, I think you've got some tough decisions to make.
Right.
I think, especially if the member who we are seeking to, frankly, force out was a contributing member to the partnership or company. If he's a silent member, I'm not sure you ever have to force him out. But if he was somebody who, and this is most often the instance, he was responsible and decided for material effort that was needed to run the company, and he just decided to stop working, you need a means to get that person out of the company without destroying the company.
Excellent. Excellent. Great question again.
And so now the next category is dispute resolution, deadlock provisions that are applicable. So deadlock provisions are really important if Dale and I are 50-50 owners and we deadlock. And there's a lot of deadlock provisions. None of them are perfect. Some, Dale and I will pre-agree that our attorney, our accountant, our trusted advisor is going to break the deadlock if necessary. Or we're going to hire a mediator or arbitrator who will break the deadlock if necessary. The dispute resolution, which is very similar, there can be different levels of dispute resolution. Typically what you see is Dale and I are going to be obligated to meet in good faith and confer and try to work it out for some period, say 10 days. If that doesn't work, we're going to go to mediation. Now, of course, mediation is non-binding. We're going to go to mediation in good faith for some length of time. And if that doesn't work, we can go to binding arbitration, typically with an arbitrator or arbitration forum that's pre-selected, where the arbitrator is going to simply make the decision. The nuclear option here again is always dissolution, or a shotgun provision where Dale and I simply cannot agree. One of us has to buy the other out, and we can do it by shotgun. And there's as many shotgun provisions as you can imagine, and you can be as creative as you want. But the typical customary one is, and I think the one that's most fair, is I'm going to make an offer to Dale to buy his interest for $100 per share. Dale has the option to say yes, or to buy me out at the same price. The beauty of that is it forces me to make an offer, which I have to believe is fair, because I have to be willing to either pay it or accept it.
Right.
In a shotgun. Now, the problem with that mechanism is if Dale and I are not of the same financial means, if Dale happens to be a lot wealthier than I am, and if he's the offerer, he can make an offer that I just can't match, and I'll effectively be forced out. Okay, but I got a good price, presumably. But in all of these governance decisions and issues, there's always going to be tension that you have to look beyond the obvious and figure out. Who is the better funded owner, shareholder, member here? What are the consequences of that? What we don't want to do is rely in, and I hate to say this because I'm an optimist by nature, we don't want to rely on the good nature of anybody down the road to do what's right. I've just seen too many examples where it just hasn't happened.
But these partnerships, co-ownerships, it seems risky, very risky. And as I just know so many things that started out, everything's wonderful, then it just falls apart. And so these agreements are just so important up front.
Look, in the and he was one of the founders in that case. That company's now worth $1 billion. The payout was very rich.
Right.
He is still friendly with the company. He didn't want to get bought out. He got bought out. He got his payday. He's still very friendly with the company. It was written down. There was no disputes. There was no litigation. The example that's a bad one, and I'll put some meat on the bones. It was two gentlemen I represented when they started a company. I thought they had a crazy idea. I was wrong. They made $48 million in profit in 3 years. Not $48 in revenues.
Right.
$48 million in profit.
Profit. Wow.
We had drafted governing documents for them, which they just never bothered to sign, despite our repeated reminders.
Wow.
Once they both became very wealthy guys, they found ways to fight with each other. They're fighting to this day. They've been in litigation probably for 7 years now, have spent millions of dollars in multiple states with no end in sight.
Wow, that's crazy. That's just a little piece of paper can change everything.
It really can. And I know Kevin has mentioned the Revised Uniform Limited Liability Act, and Delaware has a good act. New Jersey does. You don't really want to be relying on the limited contents of those acts. Almost all of them, and certainly the case law confirms that limited liability companies are entities based on contract, and there's very little statutory guidance. So, and most of it is not, it doesn't lead you to a place you want to be. So we strongly recommend these governing documents.
So what if someone watching this, today or in the video, says, wow, I really need to redo this. I don't have any problems now, but I can foresee I may have some problems. It's okay to call you or reach out to you or another attorney and
absolutely we do
the documents.
Yeah. So if you don't have them and you've been in business, you can certainly draft them now. By the way, most lenders, not most lenders, every lender is going to require these governing documents. They're not going to lend you money without governing documents. And I often get calls at that moment to draft governing documents because the company, the members, the shareholders want to get financing, and the bank or the lender is going to require these governing documents. So the answer is yes, you can do it at any time. You can also amend them at any time. We have done multiple amended and restated operating agreements for companies as their circumstances change and as their wishes change, how they want to govern themselves. So you're not locked into this. You are locked into it until there's a new agreement, right? You can't unilaterally tear it up,
Right.
but it's certainly a good starting point.
Interesting. Okay, great. This is fascinating.
This is important. It's restrictive covenants, and I'll use the best example. Dale, me and our partner, we own this ice cream store together. We're going to have certain restrictive covenants probably in our governing documents. One is confidentiality. Dale, you can't give out our ice cream formula. You just can't do it. It's confidential. We may have non-competition. Dale, you can't go open up a new ice cream store and compete with us.
Mm-hmm.
I say may have non-competition because if our company is involved in real estate investment, Dale's going to want to be able to invest in other real estate. Non-solicitation of employees, customers, providers, suppliers. Dale, you can't take our ice cream vendor and start a new business and solicit our employees. You just can't take our employees and leave us with nothing.
Right.
Exclusivity. This one, it depends on the business. Do we want or expect our members to devote their full business time and attention to the company? Maybe. I don't know. It could be that Dale works the night shift, I work the day shift at the ice cream store, and we're expected to devote our full time and energy. More often than not, that's not the case. We're going to be doing lots of different things. Often we will be expected to not take any action that harms the company. So there's a wide range of restrictive covenants that may be included in the governing documents. They don't have to be, but it's something that we usually at least suggest for consideration.
And so before you move on, so what are the remedies for these things? So exclusivity, somebody has another business or something. How do it's built into the document, the penalty if
it should be built into the document. And so we will likely have a provision that will allow for a forced buyout using that buyout provision for a material uncured violation of the operating agreement, right? If you violate something that's not very material important, I don't want to be able to force you out of the company. But if it's a material violation, and it's curable and you refuse to cure it,
Right.
there's going to be some consequences.
Great.
Dilution and wind down. This is often forgotten, and I'm dealing with this right now. We didn't draft the operating agreement, and the operating agreement was not very detailed on what happens when we decide to wind down the business. We've made money, we've done great. We want to wind down and dissolve the business. Or the flip side, we haven't done so well. We're not making money, and we're going to walk away from the business. Well, dissolution and wind down is a process. There's some money that's required. There's some professional fees that are often involved, and somebody has to be there. I'm dealing an example now where everybody just went their separate ways,
Right.
and there's nobody actually identified who's responsible for the wind down. Now, identifying somebody for the responsible for the wind down is kind of a dog, a watchdog with no teeth, because what do you do if he just says, well, yeah, I'm supposed to be responsible, but I'm not spending the next 3 months winding this company down. What are the consequences? We're going to force him out of the company. The company's already winding down. These are very, very thorny issues. And at this point in the life of the company, you've either made money and gone your separate ways, or you've lost money,
Right.
and this company's out there. The problem with it is it's a continuing liability, it's a continuing exposure. Your annual filing fees keep adding up. In Delaware, they can be significant. And when you ultimately go to wind down or dissolve the company, you can't do it till you pay all those fees. So we'd like to set up a mechanism which will affect the wind down and dissolution of the company. Easier said than done, but at least let's do our best to have the mechanism in place.
Interesting. Well, we have a few more minutes, and so I have a whole bunch of more. Let's see, someone else has a question, so we'll take theirs. Oh, Kevin again. Do you see potential issues with misunderstanding or misrepresentation when LLC members call or refer to themselves as partners, even though LLC membership is not a partnership? Do you see the potential for ad hoc general partnership being imputed separate from the LLC, undermining the LLC limitation of liability?
So I think, Kevin, I wish we could have a discourse here.
Yeah.
It's a little difficult, but we'll do our best. LLC members sometimes do speak of themselves as partners. I don't see that mistake made in transactional documents. So if Dale and I say, hey, we're partners in our ice cream store, I don't think there's any consequences that necessarily flow from that. And if we're doing an agreement with our ice cream vendor, we're probably going to be clear that we're members of the LLC. So I haven't seen that issue come up, but I may have misunderstood your question.
And he'll clarify. So as we look at these documents, do you have some standard? Because virtually most of them, or many of the family businesses that we work with, didn't obviously do, if they did an agreement, it wasn't comprehensive. Do you have a checklist for family businesses? It'd be interesting to do a checklist for family businesses to say this.
Yeah, I absolutely do. If you contacted me tomorrow and said, I'm thinking about starting family business, closely held business, I have a checklist with all of these issues identified, with options. And the purpose of the checklist isn't to, it's not formulaic. It's to get you thinking about the issues so that when we finally speak, you've thought about, well, do I really need to have a provision to deal with a marital distribution of my ownership interest? So it is a checklist. The other thing, and I just anticipating your question, is, we're going to develop an operating agreement. They can be very long, right? 50 to 100 pages long. They could be 10 pages long. They could be 5 pages long.
Right.
I don't favor the 5-page version, but we're going to try to accommodate what you're doing and come up with something that isn't overly complex, that you need a lawyer to understand, unless that level of complexity is needed. And sometimes it is. The operating agreement for that company that's now $1 billion, I drafted the first version. We're up to our 4th version. It's a very different version now because it's a much bigger company.
Right. We should talk about that, because we would love to at least share some of those points with some of the family businesses so they can begin to think about it. Let's see if I have another. So he was just saying, I have seen attorneys at LLC law firms refer in writing to themselves as partners of the law firm, even though they are members and presumably are not really partners also.
Yeah, so the legal world, the legal community, it's a funny place. You will see attorneys refer to themselves as partners because they've been named a partner at the firm, but they actually don't have any ownership interest. I'm a partner at SPSK. I do have an ownership interest there. But truth be told, I was a partner at my old firm, now as a young lawyer, more than 20 years ago, and I didn't have any economic ownership interest in that company, in that law firm. That law firm's gone, by the way, for lots of good reasons. But that's a great question, and I'm not exactly sure why the lawyers seem to do that a little differently. But if you do see a lawyer refer to him or herself as a partner, he or she may or may not be an owner of that firm.
Interesting. So I would, and if you're interested, I've written a number of articles about entrepreneurship, about 11 of them last year, and so to even write, because this is really important stuff that, and I say for all local small businesses, but certainly family members, we just see so much conflict in family business, and had they had an agreement, and also almost a new agreement has to be done during generational transfers.
Oh, absolutely.
Right.
Yeah, absolutely. And in fact, when a member changes, it's whether it's generational or otherwise, that's a great opportunity to look at the operating agreement. So when a member changes, you can do a simple joinder agreement saying Dale has sold his interests out, and Judy's the new member, and we do a simple joinder agreement, and Judy now joins in with the old operating agreement. But it's also a great opportunity to revisit the operating agreement and see, should we be making some changes? And again, now you get back to that very threshold question: under what circumstances can the governing documents be changed? Should it require unanimous approval? Unanimous approval absolutely makes sense in our 3-member company. We should all agree on changing the governing documents.
Right.
It might make less sense if we have 100 shareholders, some of whom are. So there's always that tension there. Apple is going to change it. If you're an Apple shareholder, they're going to change their governing documents without consulting with you or getting your approval.
Yeah, right.
They're just going to.
Right.
But our little 3-person ice cream store, we should all be on the same page on that, and we should all agree.
Now, we haven't talked, now I have a foundation, a nonprofit. We haven't talked much about nonprofits today. And so do you work with nonprofits with these kind of legal documents as well?
So nonprofits are very different animals. One of my partners, her practice is Farah Ansari, is devoted to nothing but nonprofits. So when I have a nonprofit, and I was representing the Cape May Jazz Festival, I honestly, I turned it over to her because those rules are very specific.
Right.
We also represent it used to be called the Lake Mohawk German Christmas, but now they got a new generic name. They put on a big German Christmas festival every year. That's a nonprofit. I turn that over because the rules are very specific. Right.
So, and the other thing that we didn't talk about is our benefit corporations. And so, and now New Jersey, I know California and New York were among the first. Do you do anything with benefit corporations?
I don't.
Oh, you don't? Okay. But the law is, New Jersey does have a benefit corporation law. And as I understand it, benefit corporations are corporations that allow, revenue to do socially good things, but it's a for-profit business at the same time.
Yeah. Yeah. And again, I suspect, I'm sure that Farah Ansari, one of our partners, is well-versed in that. She represents, I would hazard a guess, 50 to 100 nonprofits.
Oh, really?
She may represent more.
Okay.
Yeah, she's the person to talk to about that.
And so related to that, and I'll ask you, and the reason that benefit corporations came up is that if you're in an LLC or a C or an S corporation, and you're the CEO and you do things that are socially beneficial, but don't maximize profits, you can get sued. Is that correct?
Well, in the abstract, I don't think there's any laws that require the CEO or any manager to maximize profits or get sued. There's fiduciary duties.
Right. Okay.
And so you have as a manager, president, any officer, you have fiduciary duties to the company. You're also, the flip side of that is you're also protected by the business judgment rule. Okay. So you decided to short Tesla, which might have sounded like a good idea 3 or 4 years ago and turned out to be a very bad idea,
Right.
you're not going to be sued. You're
Right.
protected by the business judgment rule.
Okay. Interesting. Well, we're at the end of time, and Michael, this has been really, really, really interesting. I just want to thank you for your time. It's great getting to know you, and clearly, you know what you're talking about. And so, let's talk some more about, especially with family and small businesses, because I see these mistakes, all the time, and they're living the consequences of not doing it the right way. So, as I said, maybe we'll do an article or something together around that.
Kevin, I'd love that. And also for anybody who's on this, and if they, as a practice, I don't charge for my time, even with clients who have engaged me for phone calls and emails. So my clients call me anytime and there's no charge for any of that. I certainly won't charge people who aren't a client. So anybody on this Zoom who wants to call or email me with questions, obviously there's no charge for any of that. They should feel free to do so. And Kevin, if you're still on, would not mind talking to you and debating some of these issues, or at least discussing some of these issues. You sound very well versed in these areas.
Yeah, he sounds very. And one real quick one that he put up. Do you think judges in New Jersey are pretty strict in applying these operating agreements, or are they more lax in other states, or does it vary?
So my experience has been New Jersey, Florida, Texas, California, New York. I think all of the judges are very inclined to apply the operating agreement. They are contracts. And
Right.
A judge who is inclined to enforce a contract, and they all should, will enforce the contract as written. Some of the black letter law that folks who are legally trained will know, they will not write a better contract or worse contract for you. They're going to enforce the contract as written. Generally, they will not look outside that contract for what we call parole evidence unless there's some vagueness in the contract. So the operating agreement is clear. It spells out remedies, rights, or obligations. The judge is absolutely going to enforce that.
Perfect. Well, thanks again, everybody. Thank you for watching. And again, this is going to be taped on our YouTube page. So have a great weekend.
Thank you, everybody.
Take
Thank
care.
you, Dale.
Bye-bye.